general elections met the standards of integrity, verifiability, security, transparency to guarantee accurate and verifiable results. The second issue relates to the question of whether there was interference with transmission, and it is to the effect whether there was interference with the uploading and transmission of Form 34A from the polling stations to the IEBC public portal. And the last issue that we will be dealing with Dr. Mudomi is the question of whether there are differences in Form 34A, and the wording is whether there was a difference between Form 34A uploaded to IEBC public portal and the Form 34A received at the National Tally Center and Form 34A issued to the agents at the polling stations. Now, my lords and my ladies, some of the issues that I will be discussing, or rather some of the issues we will be discussing with my learned colleague, are issues that have been discussed, but we must mention them, especially considering what the petitioner in the petition that we are dealing with, the one by Honorable Raila, states at paragraph 35 of his petition. And in that petition, I'm just reading the second sentence of that plea, where he states, the evidence shows that the acts complained of were committed by third parties, senior employees of IEBC, acting in connivance with the second respondent in order to achieve a predetermined outcome in favor of the ninth respondent, and the ninth respondent for purposes of this petition is the first respondent. And so we are coming from the position that we maintain and insist that there was nothing that the first respondent did that could be said to have exceeded or to have amounted to collusion with the IEBC. And I would like to start my submissions by reference to the issue of Form 34A and what the first respondent and the second respondent did. My lords and my ladies, in Mainakia it was determined that Form 34A is for all practical purposes cast in stone. What Form 34A contains is the last word in respect to the wishes of the voters in the given polling station. And if it has to be in any way impeached, it is only when it has been brought to court. And so in recognition of that, the first respondent, as allowed in law, availed his agents at the polling stations to participate and watch over the process of the elections. And we wish to emphasize that the place of agents is a very material part of this petition. It is going to be a very important issue in your determination of this petition, because the bulk of the evidence in respect to the issue of Form 34A in this petition is the allegation by one Arnold Ochieng, an advocate, saying that he received Form 34As which showed that the data in the Form 34A in the public portal, the data in Form 34A that the agents of the petitioners had, and the data in Form 34A that were brought by the returning officers to the National Tally Center were different. And so the question of whether or not there were agents, whether they could be trusted, and so on and so forth is important. But for purposes of the first respondent, we wish to maintain the position that he had agents, and those agents are failed to him Form 34A through his lead agent. And after the Form 34As had been filled at the polling station, and all the agents available had been invited to endorse and confirm that the data captured in the Form 34A were true and accurate. After that had been done, the first copy of the Form 34A was then transmitted to the National Tally Center, the public portal. The other one was then taken to the National Tally Center. Now, I just want to emphasize two issues in that. One is that both the parties for the petitioner and the parties for the first respondent, had a chance to participate. The second thing I wish to emphasize, my lords and my ladies, is that in the entirety of the petition, none of the Form 34As at the point of the polling stations have been presented as having been challenged at any point. So that then the irresistible conclusion that should be made from the point at which the Form 34A originates is that those Form 34As represented an accurate state of affairs at the polling station, both in terms of data and in terms of the integrity of the process of voting and the counting of the votes. And as I said, then the Form 34As find their way to the National Tally Center, both in terms of transmission and the physical delivery by the returning officer. Again, agents for both parties were given a chance, and as allowed in law, the first respondent made sure that he had representation of his agents and has presented some of those agents to vindicate and verify that the data that was eventually verified at the National Tally Center were the accurate data of what happened at the polling station and passed on to the National Tally Center. I would like also to emphasize that the two things that were supposed to be done at the National Tally Center was to determine the data, and secondly, to establish the security features of the Form 34As. Having said that, my lords and my ladies, and considering that especially at issue number 3, your attention is on the propriety and the integrity of Form 34A, I must submit that the petitioners have not adduced any evidence of any challenge of any Form 34A at any point in the national tally. And this is the second chance they have, having had an initial chance at the polling stations. There is none of the Form 34As that have been challenged. It is with this state of affairs then, and as a result of this process, that eventually we have the declarations of the result coming out to indicate that the total valid votes cast were 14,213,027, being a product of a process that was interactive and where all the parties were involved. It is a product of this process also that comes out with the result that the first respondents' total votes were 7,176,141. Now, the process of verification of the Form 34As before they were transposed to Form 34C is a process that took 6 days. And over the period, all the 6 days, my lords and my ladies, as I already indicated, there was no objection to the verification of the Form 34As. It is our submission, my lords and my ladies, that the petitioner, through his agents, were happy with the process up to the last minute when the tallies were done, and it reflected a win for a party other than the one they wished. So that the reluctance and even this petition is based on objection as to who the Kenyans had wished to be their president. Having said that, then I would like to move on to the main party who has challenged Form 34A. The witness the petitioner has brought for purposes of challenging Form 34A, being one Mr. Arnold Ochieng, and especially all the respondents have referred to him. Probably I shouldn't miss the opportunity to mention that Arnold Ochieng is an advocate. And some of the criticism we have about his affidavit and what it contains is to be looked at with the higher regard of the fact that being a lawyer, he should know more. One, my lords, he has sworn the affidavit and attached Form 34As when in his affidavit he acknowledges he was not an agent at any point. And so it brings in the point that that affidavit and what he says is hearsay. Number two, he produces about 20 Form 34As, and in all of them, he does not mention the agent who gave him. He does not say, I received. He says this Form 34A is defective because it has data that is at variance with the public portal. It is at variance with Form 34A that was brought to the National Tally Center. But he does not say at any point which of the agents gave him that Form 34A. Number three, he brings the Form 34As and says they were given to him in terms of either photocopies or photographs from the agents who were on the ground because he was not there. But he does not produce a certificate of electronic evidence to show that those agents have confirmed that indeed this Form 34A was properly generated and is capable of being treated as evidence of any property value in the consideration of your case, of this case, sorry. And lastly, my lords and my ladies, Mr. Ochieng then certifies that these Form 34As that I'm producing, having skipped, of course, certification from the point of agents, he does a certificate himself saying this Form 34As that he's presenting to court meets the criteria required by Section 106 of the Evidence Act, the electronic evidence. That certificate, my lords and my ladies, says it is a certification of a production of a video, when in fact the attachment he produces are forms, Form 34A. And so, my lords and my ladies, in considering that item number 3, the issue number 3, we pray that you take into account that the principal witness on that issue of Form 34A has adduced absolutely nothing in support of the petitioner's case. In firstly, my lords and my ladies, on our part as the first and second respondents, and similar to what the third and the fourth respondent did, was to pick the Form 34As that the petitioner had brought and said they demonstrate that the Form 34As lacked integrity. And then we went to those polling stations and asked the agents and the presiding officers in those polling stations to confirm to us what they know about the Form 34As that Arnold had brought to this court. And my lords and my ladies will see that we have attached over 6 affidavits from the agents, and each of them say each of those forms were falsified. And I'm using the words falsified to be polite about the issue. I know my colleagues have said worse than that on that issue. The third issue I wish to take up on the issue of Form 34A, the first one was the process. The second one is the evidence against the first and second respondent on that. The third issue I wish to take up about that Form 34A relates to the issue of how they were housed in the public portal and the transmission. And the first point I wish to observe and submit, my lords and my ladies, is that we pray that the court keeps the conscious awareness that the elections were not electronic elections. They were manual. The only issue that was electronic was voter registration, voter verification, voter identification, and the results transmission. And in these proceedings, our focus and attention relates to transmission. Having said that then, my lords and my ladies, we pray that the court takes on board the point that is made in Section 39 of the Elections Act, Section 39 1F, and the decision of this court in Odinga 2013